let's start with Children's Court, folks. As I've mentioned previously, the Children's Court is a part of the district court, and every seat of the district magistrates court also functions as a children's court, as set out in the Children's Act, being the empowering legislation. What are the powers of the Children's Court, folks? Very, very important. Make a big note of Section 45(1) of the Children's Act, because this tells you which matters a children's court may adjudicate. As I understand, there was a recent amendment to the Children's Act, and obviously the powers of the Children's Court have now recently been expanded to also include guardianship matters, where previously the Children's Court could not adjudicate on issues of guardianship. Hopefully, we will be able to put on a presentation regarding those amendments in the near future, just to acclimatize those on our platform to what the amendments entail. Now, let's look at the matter that can be adjudicated by the Children's Court. The Children's Court, subsection A, can look at the protection and well-being of a child. Sub B, the care or contact with care of or contact with a child. And really, folks, I would say the vast majority of matters in the Children's Court deal with the first two sections: protection and well-being of a child. And we had a very nice, robust debate on the issue of whether a child is a child in need of care and protection a few days ago. And these are obviously issues that are dealt with by the Children's Court. And then also care and contact disputes. Very importantly, folks, primary residence, whilst we use it all the time, is not a recognized term in the Children's Act. We talk about care and contact, both of which are very thoroughly defined in the Children's Act. And I would go so far as to say the concept of primary residence really finds its foundation and its roots in the parental responsibilities and rights of care and contact. The Children's Court can adjudicate a matter relating to paternity of a child, the support of a child, provision of ECD services or early intervention services. It can adjudicate issues of maltreatment, abuse, neglect, degradation, or exploitation of a child, except criminal prosecutions, which would obviously be dealt with by the criminal courts. And obviously, as I mentioned earlier, the Children's Act, Children's Court, apologies, is a civil court and not a criminal court. It can deal with the temporary safe care of a child, alternative care of a child, adoption matters, including inter-country adoptions, and it can deal with child and youth care centers, partial care facilities, shelters or drop-in centers, or any other facilities purporting to be a care facility for children. And then last one, K, very, very important, we've got this catch-all: any other matter relating to the care, protection, or well-being of a child provided for in this Act. The Act obviously being the Children's Act. So the Children's Court has very, very broad powers to adjudicate children's matters, obviously now made broader by the amendments to the Children's Act, which I will also distribute with our course material today, and which I'm eternally grateful to have received on the WhatsApp group from one of our participants. Right. Let's look at the regulations to the Children's Court. Regulations very often overlooked, but very, very important, especially in Children's Court matters. Now, I think what we must just be mindful of whilst we go into the regulations, if I may kind of wax lyrical a bit, the road to hell really is paved with good intentions, and the best laid plans of mice and men often do go awry. And I think there is no better example of this than Regulation 6 of the Children's Court regulations, which I'm sure various of my attorney colleagues practicing in the Greater Gauteng area will attest to when we look at some of the time periods in Children's Court. If we look at the regulations, we actually have a very, very strict time period. And whilst we know the High Court has been very critical of the notion that all children's matters are inherently urgent, the regulations to the Children's Court do to a large extent mirror that sentiment, in that there are very, very strict time periods which are imposed in terms of the regulations. Now, understand that a person who approaches the Children's Court will almost invariably approach the Children's Court on a Form 2, which is the prescribed form for instituting proceedings in the Children's Act, obviously subject to some exceptions here and there, but except as a given for purposes of today's discussion that we're going to be talking about Form 2s. Now, subsection 1 of Regulation 6 says a person referred to in Section 53 of the Act, which is a person who intends to approach the court, must notify the clerk of his or her intention to do so on a form which corresponds substantially with Form 2 of the annexure. So, step 1, you fill in your Form 2, you go to the clerk of the Children's Court and you say, right, here is my Form 2, I want to stop Children's Court proceedings. Now, in subsection 2, I know I'm going to get quite a few sniggers from legal practitioners, specifically relating to the time periods. The regulations say the clerk must, not may, not can if they feel like it, can if you buy them Nando's, they must, within 5 days after receipt of the notice, refer the matter to a presiding officer of the court, and then that presiding officer must, within 7 days after receiving the documentation relating to the matter, A, refer the matter for mediation to a family group conference or a lay forum, or take the matter to a pre-hearing conference, or refer the matter to court. So in essence, the regulations envisage a situation where there are severe time limits, and in essence, within 12 days of having referred the matter on a Form 2, obviously unless it is an urgent matter which needs to be dealt with earlier, that Form 2 with the supporting evidence and or the affidavit, for example, I see Karen just pointed out some courts do insist on an affidavit together with a Form 2 for some reason. That would have been before a magistrate, and the magistrate, or the commissioner in this case, who is a magistrate as it were, must then make an election to refer the matter for mediation, go to a pre-hearing conference, or refer the matter to court. In my experience, in most cases, the matters get referred to court. I'd love to hear from some of our colleagues what their experience has been. Now, we know almost invariably you do not get to court within 12 days after doing a Form 2 in general. There is good news, however. Some magistrates' courts are extremely on the ball. I had a matter last year, or one of my attorneys at least had, Krugersdorp Magistrates Court, and I suppose let's share the kind of good experiences between ourselves, where we had an extremely urgent matter, and we managed to get helped within 48 hours. The Form 2 of the Children's Court relates to Section 53, so it goes without saying, when you complete it, have Section 53 next to you. Also have Regulation 6 next to you. We ran through that a bit earlier. So, at the top, you have file number and particulars of the children involved, because obviously this is the starting point of any Children's Court matter. Interesting affidavits of other persons or documentary evidence in support of the matter must be attached. And then secondly, it just tells us what the Children's Court can do after you've referred the matter to Children's Court. Now, Once you've gone through and you've put in the children's details, just have a look. Let's go through it a bit more slowly. Surname, names and gender, child 1, 2, 3, 4, 5, ID numbers, dates of birth, residential addresses, all of the basic vitals for the child. You get into other relevant information. This deals with financial position, availability of transport, socioeconomic status, whether you need an interpreter, special needs, etc. So that is the first section of the form, relates to the child or the children involved in the litigation. Part B of this, we look at the name of the person acting on behalf of. So it is the particulars of the child who is affected by or involved in the matter. So if the child comes to court themselves, this would basically echo the top one. Or the person acting in the interests of the child, or the person acting on behalf of the child who cannot act in their own name, or a member of a group of a class of children in the public interest. So in short, this is the name of the person who really launches the proceedings. Then we go into the particulars of persons having an interest in the matter. That would be, for example, parents, grandparents, etc. And then part D, you go into the particulars of the matter. Now, folks, children's matters can be very, very, very complex. This block over here is probably not sufficient to give the court a full rundown of what you want. As Karen indicated earlier, some courts, in fact, want you to do an affidavit together with this form. In my jurisdictions, I haven't heard any serious incidents of courts not issuing because you haven't done an affidavit. I think it is advisable, however, specifically if it is a complex matter, to do an affidavit and attach it to the Form 2 and then just a list of the documents. Now, very, very, very importantly, this form that we got from Department of Justice and Constitutional Development does not make provision for it to be under oath for some reason. Yet another good reason to do an affidavit to get your evidence before court appropriately. This is the form that you would, as we spoke about in the first section of today's session, lodge with the clerk of the children's court. They must within 5 days take it to a magistrate. The magistrate must within 7 days refer the matter to court, pre-hearing conference, or a lay forum for mediation. Now, once this form has been lodged, the court really kind of takes over to a large extent until you hear back from the court, who might then send it to mediation or to court, etc. That is the Form 2 in terms of the Children's Act.